Derek, in your part two, the state's claiming you've got prior valid convictions for escape from 2016 out of Denver, escape from 2013 out of Denver, dangerous drugs from 2013 out of Denver, dangerous drugs again from 2012 out of Denver twice, and then possession of a controlled substance out of Houston from 2010. State wants to use those 6 priors against you to
Hi guys, it's Kathy. I hope you're doing well. So, this video is brought to you by Pepperoni Pizza and Wings. Fozzie sent me a pepperoni pizza and wings tonight for dinner to help me make video, make any video. So, just so you know, I'm a single mom, and I know my kids are older now, but they don't cook. They can cook. They don't cook. And every single day of my life I have to keep figuring out dinner alone. It's just me, dinner, 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 dinner. And yeah, I can hear everybody, just make them do dinner, just make them do dinner. I understand that. I do. I This is a problem of my own making. I know. But when someone takes care of dinner for me, that's such a gift. It's not just pizza and wings. It's me not having to deal with just that for a night, which is so awesome because it is every single night. So, back to the video. Thank you, Fozzie. I appreciate it. Back to the video. So we hear this guy's charges, all from Denver. And you would think, yeah, that's normal for Denver. That's not anything shocking. Denver's a big city, there's lots of crimes in big cities. We're not in Denver, guys. We're not even in Colorado. This is Minnehaha, South Dakota. And I love Minnehaha, South Dakota just because of the name. It makes me feel like everybody's happy. There's picnics. Just like Fleischer says, Bambi running around the woods. It's Minnehaha. Well, I put this video out because normally when I get Minnehaha, that's what it is. It's traffic tickets, domestic violence, and DUIs. Just That's just what I get. Well, man, this docket today shows us a completely different side to Minnehaha, guys. So, no defendants do anything crazy here. There's no screaming, there's no yelling. All this is a progressively worse docket of serious issues in poor Minnehaha, and we need to make it stop, guys. We need Minnehaha out of everywhere to be a safe place.
increase your level of felony offense by 2 levels. So when I talk to you about the felony charge, I'm going to bump it up by 2 levels. Counts 1 and 2 are both charges of aggravated assault. Count 1 says that on May 25th, 2024, you committed the offense of aggravated assault by attempting to cause serious bodily injury to Daryl Calvin Holmes under circumstances that manifested an extreme indifference to the value of human life. In count 2, you're charged on or about May 25th, 2024. It says you committed the public offense of aggravated assault by knowingly causing or attempted to cause bodily injury to Daryl Calvin Holmes with a dangerous weapon, a knife, contrary to and in violation of South Dakota law. Charged in the alternative, Isaac?
I apologize, Your Honor, one moment. I believe so.
Okay, Jeff, do you know? If they're charged in the, okay. So Derek, 2 different ways to read this. If counts 1 and 2 are the same date, the same crime, aggravated assault, the same victim, so they might be what we call charged in the alternative, where it's really one incident, but they've charged you 2 different ways. So it's 2 different ways for the state to prove its case, 2 different ways for a jury to convict you, but only one way for the judge to sentence you. You could only be sentenced on one.
Okay.
So your class 3 felony becomes a class 1 felony. So as to each one, you're facing 50 years in the pen with a $50,000 fine because of your past. They take your
Yikes.
class 3 and they bump it up 2 levels. They could be charged independent of one another, and then you'd be facing 50 years on each one. So it's either 50 years max or it's 100 years max. I'm telling you both ways because I have to give you worst case scenario here today. Jeff, you're willing to waive on the misdemeanor?
Yes.
Giving you to Judge Song. Who for the state, Isaac?
Jennifer Heenick.
If you look in the background, in the first row, there's a woman there with brown hair, and it appears to be like she's crying, which makes sense because she's in jail. But she keeps wiping her eyes. I don't think she's crying, guys. Hold on. She's coming up soon.
Okay, Derek, giving you those dates in paper format. Make sure you're doing a good job staying in contact with Jeff. Jeff, anything further?
Would the court address bond at all?
Sure.
Right now he's on a 25,000 cash only, and I believe there is a parole hold, but the parole hold is South Dakota. He's here on an interstate compact from Colorado. That's why he's here, and he's he's got a place to stay. He's got a job. He's got his girlfriend and their child that he lives with, and since he's been staying here, he's had zero issues until this came up. We requested to be lowered. I don't know if it'll have any impact due to the fact that, again, with the parole hold.
The parole hold, yeah, yeah. Okay, Isaac?
Thank you, Your Honor. The state is requesting that bond remain the same at $25,000 cash. Would ask also a no contact with the co-defendant, which is Anthony Lloyd, as well as no contact with the victim in this case. As the court already noted in the part 2, there are numerous escape convictions. It appears there are limited ties to the community. I would note that the allegations do allege a stabbing here where paramedics had to come to the scene. Law enforcement came upon the alleged victim who was covered in blood, and law enforcement had to use a towel to apply pressure to the victim's injuries to stop the bleeding. I think this is extremely dangerous behavior, and given his history and the allegations here, the state believes bond's appropriate.
I'm going to leave bond as previously set by the court at the 25,000. I'm going to also impose the no contact both on that alleged
Wait a second, Judge. You didn't give a PR bond? That's crazy.
victim, Calvin, and I want to no contact with Mr. Lord, the co-defendant. I would say, Jeff, if it turns out that you know for sure he's being held for sure, and he wants a PR on this, you can certainly address that with Judge Song.
All right.
But for now, I suppose he can at least argue double credit.
All right. Thanks, sir.
Is that your only one?
Yes, Your Honor.
It's appearing with Brianna Miller, and I do have an application for court-appointed counsel.
Okay, 223624.
You're going to see it in a second when she looks up. It's not easy to see, but you can see it. She's got a humongous black eye. And I'm pretty sure that her cheek and mouth are swollen on that same side too. So she wasn't sitting back there crying. Well, she might be. But I don't think she's crying. I think it's because of her humongous black eye. And we don't know. We don't know if she got this black eye in jail or if she got the black eye before she got into jail. But I would love to know.
And 225587 looks like warrant hearings. Brianna, did you fill out this application for court-appointed counsel truthfully and accurately to the best of your ability?
Yes, Your Honor.
Michelle, is this you or just your office?
It's mine, Judge.
Okay, I've appointed Michelle Thomas to act as your counsel in this matter. Looks like you're here on a warrant for a motion to revoke. We're going to handle 223624 first. There, Judge Hanson set you on a $2,500 cash-only bond. Looks like it says you were under a condition to obey all laws, but it says you were charged with the offenses of obstruct police, jailer, or firefighter, resisting arrest, domestic assault, simple assault, and domestic abuse, aggravated assault with a deadly weapon on January 9th of 2024. And then you were charged with 2 counts of violation of a protection or no.
Well, that explains it. So all of that, the aggravated assault, all of it, resisting police, Could have gotten her a black eye. Absolutely. But that was from January. And this was recorded today. This is live today. Well, it's not live right now, but um or yesterday, I guess. I haven't gone to bed yet, so today is still yesterday. So this must have, I mean, it just must have happened in jail, right?
Contact order on January 16th of 2024. And then you were told you will obtain advance permission before changing your phone number, employment, or residence. You won't miss any appointments with court services. Says that you reported to court services in December, but they weren't in the office at the time, and so you provided a phone number, and then they spoke to you on December 4th and requested that you come in and report, but you no-called, you no-showed for that scheduled meeting. Then they attempted to call you, and the number was disconnected. They sent a letter to your address, asking you to report back to court services. You no-called, no-showed for that appointment. Then there's a condition, you shall not consume alcoholic beverages, and it says you were detained on January 9th with the PBT of 286 and on January 16th with the PB2 of .06. Those are the allegations against you. When I look back at your sentence in that matter, it says 3 years in the state pen on a possession of a controlled drug or substance, and that's going to be consecutive to the other one we're here to talk about. So if Judge Hanson finds that you were not successful and you did violate the terms of your probation, she can send you to the pen for the 3 years there. You understand that?
Yes, Your Honor.
Okay. And then the next one is 225587, $2,500, again, cash only. Looks like all the same are allegations as to your violations, and she's got another 3 years there consecutive for you waiting on a PCS. So you're facing 6 years in the penitentiary if Judge Hanson finds that you violated the terms of your probation. Any questions about that, Brianna?
No, Your Honor.
Okay, so the next thing that happens, you get a hearing date in front of Judge Hanson. At the hearing, you can admit or deny the allegations. If you deny the allegations, the state needs to try to prove them, but they don't need to prove them beyond a reasonable doubt. They just need to make Judge Hanson more than reasonably satisfied that you are in violation of the terms of your probation. That's what happens in both. So your big choice is admit or deny, and then see what the state can prove. Any questions about that?
No, Your Honor.
Okay, Michelle, anything further?
No, we're going to reserve bond for today, Judge.
Okay. Questions about the rights that I met?
Again, no PR bond. It looks like all that other stuff was in the past. She's going to jail for 6 years maybe because she didn't call her probation officer, and she doesn't get a PR bond.
Read to you.
No, ma'am.
Okay. In your part 2, the state is claiming you've got prior valid convictions for DUI 6th out of 2017 Minnehaha County, possession of a controlled substance 2024 Minnehaha County, and receive or transfer or possess a stolen vehicle from 2024 Minnehaha County. State wants to use those three priors against you to increase your level of felony offense by 2 levels. In counts 1 and 2 of your indictment, you're charged with aggravated assault. Allegation in count 1 is May 21st, 2024, you committed the public offense of aggravated assault by attempting to cause serious bodily injury or causing such injury to Faraj Ashur Akwani under circumstances that manifested an extreme indifference to the value of human life. Count 2 charges, potentially in the alternative. Isaac, take a look. May 21, 2024, you committed the offense of aggravated assault and that you did knowingly cause, attempt, or cause to bodily injury to Faraj Ashur Akwani with a dangerous weapon, a firearm. Both of those start as class 3 felonies. For you, they're going to jump up to a class 1 felony. So as to each one, you're facing 50 years in the state penitentiary with a $50,000 fine. If they're charged in the alternative, it means you could be found guilty of both and the state could prove your guilt as to both, but the judge could only sentence you one time. So that would just be one term of 50 years with $50,000 fine. If they're not in the alternative, then you've got 2 of them and there's up to 100 years available to the court. You understand?
100
Okay.
years.
Count 3 is discharge of a firearm at an occupied structure or motor vehicle. Allegation is that you, on or about May 21, 2024, committed the public offense of discharge of a firearm at an occupied structure or motor vehicle. that you did willfully, knowingly, and illegally discharge a firearm in an occupied structure or motor vehicle contrary to and in violation of South Dakota law. That's also a Class 3 felony, also bumps up to a Class 1. That's 50 years with a $50,000 fine. Any questions about that?
No.
Showing you're going to Judge Hanson.
Judge Hanson does not live stream. Sorry, guys.
Okay, Dory, giving you those dates in paper format. Make sure you're doing a good job staying in contact with Matt. Matt, anything further?
No, Your Honor, we'll reserve bond.
Okay, we'll be in recess then.
Thank you.
Good luck
Your
with
part
that.
2, Todd, says you've got prior valid convictions for felony failure to appear, 2013 Minnehaha County, unauthorized ingestion of a controlled substance, 2016 Charles Mix, receipt of a stolen vehicle, 2022 Minnehaha County, possession of a controlled substance, 2022 Minnehaha County, grand theft, Lincoln County, 2022. None of those rise to the level of violent, so it means they're just seeking a 2-level enhancement. So when I get to your felony charges, we're gonna up those by 2 levels. Count 1 charges you with aggravated eluding from May 7th, 2024. It says you did, as the driver of a vehicle, flee from Officer Nelson Leecraft or attempt to elude the pursuit of Officer Nelson Leecraft. And during the flight or pursuit, you operated the vehicle in a manner that constituted an inherent risk of death or serious bodily injury to a third person. That is a Class 6 felony for you. It bumps up to a Class 4 felony, which is 10 years in the pen and a $20,000 fine. Count 2 charges you with knowing possession of methamphetamine from May 23rd of 2024. That's a Class 5 felony, bumps up to a Class 3 felony, which is 15 years in the pen and a $30,000 fine. Count 3 charges you with possession of a firearm by one with a prior drug conviction. Specifically, it says that you were found in possession of a firearm on or about May 23rd, 2024, despite the fact that you had
It
a
was
prior
mouthwash.
felony conviction for possession of a controlled substance from 4/19 of 2022 here in Minnehaha County. That starts as a Class 6 felony. For you, it will bump up to a Class 4 felony, which is 10 years in the pen and a $20,000 fine. And then you've got count 4, which is possession of a firearm with an altered serial number. Allegation there is that on May 23rd, you possessed a firearm on which the manufacturer's serial number had been changed, altered, removed, or obliterated in violation of South Dakota law. Again, a Class 6 felony moves up to a Class 4 felony, which is 10 years in the pen and a $20,000 fine.
You don't understand, Judge. His grandmother was sick, and his dog was alone, and the gun fell into the car because he was driving really fast, and it must have kicked up from the wheel and fell into the car, and he wasn't eluding police. His grandmother's sick, so he was on his way to get her, and it's crazy that ingestion of fentanyl or meth or whatever it was is 10 years in jail. That's just not right. They don't mess around, do they? They give out 10 years, 20 years, 30 years, $20,000 fine, $50,000 fine.
Waived on the misdemeanor. So any questions about any of that?
No,
Todd?
ma'am.
43. Showing this goes to Judge Hanson. 3532 and 243612. Marcel, any questions about the rights that I read to you?
No, ma'am.
Okay, we're gonna do these in order. We're gonna do 243532 first. There, the state's claiming you've got a prior valid criminal conviction for assault with intent to do great bodily harm, but less than murder or by strangulation from circuit court in Michigan, I think, from 2010. State wants to use that one prior against you to increase your level of felony offense by 1 level. Here you're charged with 4 counts of domestic assault at Class 3 felonies, so each of those would rise to a Class 2 felony, which is 25 years in the state penitentiary with the $50,000 fine. So as to those first 4, we'll go through those. Count one says on May 18th, you committed the offense of aggravated assault domestic by attempting to cause serious bodily injury or causing such injury to Kevin Ray White under circumstances that manifested extreme indifference to the value of human life. Count two says on May 18th, you committed the offense of aggravated assault domestic by knowingly causing or attempting to cause bodily injury to Kevin Ray White with a dangerous weapon, a handgun. In count three charges, May 18, 2024, it says you committed the public offense of aggravated assault domestic by assaulting Kevin Ray White with the intent to commit bodily injury and which resulted in serious bodily injury. And in count four, it says that you on May 18th committed the offense of aggravated assault domestic by attempting by physical menace with a deadly weapon, a handgun, to put Kevin Ray White in fear of imminent serious bodily harm contrary to and in violation of South Dakota law.
She could have just said attempted murder instead of all those words.
I think those are charged in the alternative. I don't know for sure. So it's 4 charges. They're all ag assault. They're all the same date. They're all the same alleged victim. If they're in the alternative, that means one of these applies. 25 years with a $50,000 fine one time. You can be charged 4 times. The state can get the jury to convict you 4 times, but a judge could only sentence you once. That's if.
Okay, I just got to ask, leave a comment. Have we ever seen a domestic violence get 25 years? I mean, I've seen probation, and of course probation. But 25 years, have we seen that?
They're charged in the alternative. Otherwise, if there's 4 separate instances, you punched him, you threatened him with a gun, you did 4 different things, then you're looking at 25 years times 4. Okay, and then
100
in count
years.
5, it's witness tampering, withholding evidence. There, the allegation is that you, on or about May 18th, committed the offense of tampering with a witness by threatening to injure or injuring Kevin Ray White or his property, or with the intent to influence Kevin Ray White, offer, confer, or agree to confer any benefit on the witness or prospective witness in an official proceeding, or who corruptly persuades or corruptly influences another person to induce the witness to withhold any testimony. So that starts as a class 4 felony for you, moves to a class 3 felony, which is 15 years in the state pen with a $30,000 fine. That's the first case. Any questions about any of that, Marcel?
No, ma'am.
Okay, then we move to 24-3612. In that matter, again, the habitual offender, part 2, says assault with intent to do great bodily harm but less than murder or by strangulation, from 2010 out of Circuit Court, Michigan. The indictment there says you're charged with witness tampering times 3. Those are all class 4 felonies. For you, with your enhancement, they'll move to class 3 felonies, which is 15 years in the pen, $30,000 fine. Count 1 says witness tampering by testify falsely. It says that on May, I don't know. What do you think that date is, Isaac?
On May 18th.
Yeah, it's been crossed out.
Modified it to 22nd, Your Honor.
22nd, you think? Okay. It's scribbled and I apologize, but May 22nd committed the public offense of tampering with a witness in that you did injure or threaten to injure Murdy Kemp or property, or with the intent to influence Murdy Kemp, did offer, confer, agree, or agree to confer any benefit on or punishment, corruptly persuade or corruptly influence someone else to induce the witness to testify falsely. That's the first one. Count 2 is, again, I think, the 22nd of May, tampering with a witness. It says you injured or threatened to injure Murdy Kemp, all the same language. And count 3 is May 22 again, tampering with a witness. You injured or threatened to injure Murdy Kemp or property, or agreed to confer a benefit, or corruptly persuaded or corruptly influenced, all the same language. That one, though, is that you tried to get him or her to absent himself or herself from an official proceeding. So you tried to get him to stay away. So count 1 is you tried to get, is Murdy a boy or a girl?
It's my Aunt Murdy.
What?
It's my Aunt Murdy. She's my
Okay,
aunt.
so in count 1, it says you tried to get Murdy to testify falsely. In count 2, it says you tried to get Murdy to withhold evidence. And in count 3, you tried to get Murdy to take herself out of the equation and not come at all. So those are the allegations. They're all class 4 felonies, all to be treated as class 3 felonies, which is 15 years in the state pen with the $30,000 fine. If they're charged in the alternative, you face that punishment once. If they're not charged in the alternative, you face the punishment 3 times. Any questions about any of that?
If you if you haven't been counting along, this guy is looking at 185 years in jail for all of this, for domestic violence. 185 years in jail. So we're going to hear more about how he tried to stop his aunt from testifying, which I believe is a crime. It's absolutely a crime anywhere. But 185 years in jail. Now I know that's just the maximum. I know he's probably not going to get that, but we've never seen anything close to this before.
No, ma'am.
Okay. 32. You go to Judge Song.
Judge Song does not live stream.
It's currently at $25,000 cash in CRI 243532.
Oh, and sorry, the aggravated assaults were stamped domestic in nature, which means you also have to pay a $25 domestic violence fee, and then you have to sit for an anger management evaluation and do whatever they tell you have to do. Sorry, Eric, go ahead.
No worries. $25,000 in that aggravated assault case, $10,000 cash in CRI 243612, which is the 3 witness tampering counts. I would note that bond was reserved at the initial appearance on that CRI 243612. At this time, Your Honor, we would ask that the court consider modifying these bonds to perhaps lower cash and surety amounts. I would note that Marcel presents to the court with a 2-3 PSA score. The PSA sheet indicates that he has never failed to appear. It looks like he just has that one prior felony conviction from 2010. From what Marcel tells me, the allegations from that incident were actually something from when he was only 15 years old. It took a few years for that to work itself through the system, but was something that happened while he was a juvenile, although he was tried as an adult there. I would note that the alleged victim in the aggravated assault case did not show up to the grand jury, which I do think is significant as far as the strength of the state's case goes.
Who is that person to him?
Kevin White is his brother, Your Honor.
Kevin White's his brother, okay.
Yes. I guess I would also note, from reading the reports in the witness tampering regarding his aunt. Murdy, essentially what he is alleged to have said is along the lines, if you show up to grand jury and you testify falsely, you run the risk of getting charged with perjury. I really do not think those facts fit with the South Dakota's witness tampering statute. There is now a no contact order between Mr. Caldwell and his aunt. So he understands that there is to be no communication between the two of them going forward, regardless of whether those conversations would involve witness tampering or not. But I do think that there are significant questions about the strength of the state's case in that as well. He tells me that he could live with his grandmother here in Sioux Falls if he were able to postpone or he were released.
Does he normally live with his brother?
He usually lives with his aunt, Your Honor.
Aunt Murdy?
Yes.
Okay.
There is now that no contact order, of course, and he is more than willing to abide by that. Tells me that he's lived in the Sioux Falls area for most of his life, is employed at ARS Roofing, where he's held a position for the past 9 months, does have 3 children who he's raising, and does have extended family here in Sioux Falls as well. So, Your Honor, given all those factors, we would ask that the court consider lower cash and surety bonds here.
Isaac?
Okay, another question. Isaac's about to speak. The prosecutor's about to speak, and he's about to say what he thinks this guy did. Now, when he does that, not all of them, but there's lots of times where the defendant shakes his head yes. He doesn't say anything, but he's saying yes. He's shaking his head yes. Is that, can they use that against him if this goes to trial? Can they say that, yeah, he confessed during this hearing by shaking his head yes? Is a head shake a confession.
Thank you, Your Honor. State is requesting that the bonds remain in place. I would note that as far as the aggravated assault goes, at the initial appearance on May 21st, the state was asking for $50,000. The court issued $25,000 at that time. With regard to the witness tampering, that was a bond argument that was reserved at the $10,000. With regard to the allegations here, I think the state believes that, the state does believe that bond is merited on the aggravated assault. Would note briefly the alleged facts are that law enforcement was dispatched to a gunshot victim in Sioux Falls, Minnehaha County. Law enforcement spoke with a witness who identified the defendant as the shooter, holding a black and gray firearm. An eyewitness saw the victim crawling on his hands and knees before defendant shot him. Law enforcement conducted life-saving efforts to the victim, as there was a large pool of blood there where the victim was found. Victim was breathing but was unconscious. So that was the allegations with regard to the aggravated assault. With regard to the witness tampering, I would note that this allegedly occurred 4 days after. I believe that is where the issue was. There was the aggravated assault from May 18th, but the witness tampering is from 5.2. I think that just got screwed up originally on the indictment, but was changed at grand jury. But with regard to that matter, I would note that there was more than just saying that she's going to get in trouble in the sense of perjury. There's a recording from the jail. He was recording calling an unknown female, asking for his aunt's phone number. He then proceeded to instruct this female to text his aunt and specifically what to text her. He told her to tell her not to testify, to not show up to court, because if she does, his lawyer would fry her and she'd be locked up for perjury. I believe some of the specific messages were, it's going to be proven that he was shot standing up, say that, and you're going to go to jail for perjury for saying that he was standing over him and shot, because it's going to prove different. The female repeats that back to the defendant. He continues and not kneeling down, and she's going to go to jail for perjury. The female then reads that back to the defendant and asks her to text the aunt, and he replied, yeah, so she better stop cooperating with them with that, because I don't want her to get in trouble. Then reads on, and then he says she better not come to court because his lawyer is going to fry her. So I think there is enough there for witness tampering. I would note that the victim, or the victim of the witness tampering, did speak with law enforcement, said she felt like she was trying to be intimidated. So given that, the state believes bond's appropriate on both charges. Thank you.
Did you notice how deadly quiet it got in the gallery? It got in that little holding area. They were loud the entire time. But then once the prosecutor started talking there, everybody just shut up and started listening.
Okay, I'm putting bond on the ag assault at 10,000 cash surety, and I'm putting bond at the witness tampering at 5,000 cash surety, so you can use a bondsperson to post out. If you do get out, good behavior, stay in contact with your lawyer, make all court appearances, no contact with Kevin White or Murdy Kemp. No weapons, no alcohol, no driving without a valid license, no drugs without a valid prescription, and comply with pretrial services. There's actually a person here from pretrial services. They will meet with you. So if you bond out, make sure you're doing a good job staying in contact with pretrial services. We'll be.
Okay, so that I'm confused at this, because he's facing 185 years in jail, but he only has $15,000 in bonds total. But if you look at domestic violence, $15,000 bail is a lot. We just don't see that. We see PRs. So, yeah, I don't even know what to think about this court. And this is not normal. This is not what I see when I look at Minnehaha. I see, the normal domestic violence, the normal DUIs, and the normal traffic tickets. So this day was just, I'm just going to have to start looking at Minnehaha more, because maybe I'm just missing it. Maybe I'm just getting it on off days. But this was incredible. These people have so many years they're facing for crimes that everywhere else they don't get any, none, zero. All right, Fozzie, thank you so much for the pizza. I ate it the whole time I was making this. That's why I muted so much. I really, really appreciate you. All right, guys, thanks for coming out. I hope you guys have a good day. Bye.